Welcome to Module 3. Now, as we've mentioned before, in the United States, there is no single comprehensive federal or national law regulating the collection and use of personal data. But each congressional term brings proposals to try and standardize laws at a federal level. Instead, right now, the U.S. has a patchwork system of federal and state laws and regulations that sometimes overlap, sometimes they dovetail, sometimes they even contradict each other. In addition, there are many guidelines developed by governmental agencies and industry groups that don't have the same force of law, but are part of a regulatory set of guidelines and frameworks that are considered best practices. These regulatory frameworks have accountability and enforcement components that are increasingly being used as a tool for enforcement by regulators. There are already a panoply of federal privacy-related laws that regulate the collection and use of personal data. Some apply to particular categories of information, such as financial or health information or electronic communication. Others apply to activities that use personal information, such as telemarketing and commercial email. In addition, there are broad consumer protection laws that are not privacy laws per se, but have been used to prohibit unfair or deceptive practices involving the disclosure of and security procedures for protecting personal information. Some of the most prominent federal privacy laws include the following. The Federal Trade Commission Act. This is a federal consumer protection law that prohibits unfair or deceptive practices and has been applied to offline and online privacy and data security policies. The FTC has brought many enforcement actions against companies failing to comply with posted privacy policies and for unauthorized disclosure of personal data. The FTC is also the primary enforcer of the Children's Online Privacy Protection Act, or COPPA, which applies to online regulation of information from children and the self-regulatory principles for behavioral advertising. The Financial Services Modernization Act, also known as the Gramm-Leach-Bliley Act, regulates the collection, use, and disclosure of financial information. It can apply broadly to financial institutions like banks, security firms, and insurance companies, as well as to other businesses that provide financial services and products. GLB limits the disclosure of non-public personal information and in some cases requires financial institutions to provide notice of their privacy practices and an opportunity for data subjects to opt out of having their information shared. In addition, there are several privacy rules promulgated by national banking agencies and the Safeguards Rule, Disposal Rule, and Red Flags Rule issued by the FTC that relate to the protection and disposal of financial data. The Health Insurance Portability and Accountability Act, also known as HIPAA, regulates medical information. It can apply broadly to healthcare providers, data processors, pharmacies, and other entities that come into contact with medical information. The HIPAA privacy rule is composed of national regulations for the use and disclosure of what's called protected health information, or PHI, in healthcare treatment, payment, and operations by covered entities. Covered entities must disclose PHI to the individual within 30 days upon request. Also, they must disclose PHI when required to do so by law, such as reporting suspected child abuse to state child welfare agencies. Covered entities may disclose protected health information to law enforcement officials for law enforcement purposes, as required by law, including court orders, court-ordered warrants, and subpoenas, as well as administrative requests, or to identify or locate a suspect, a fugitive, a material witness, or a missing person. A covered entity may disclose PHI to certain parties to facilitate treatment, payment, or healthcare operations without a patient's express written authorization. Any other disclosure of PHI require the covered entity to obtain written authorization from the individual for the disclosure. In any case, when a covered entity discloses PHI, It must make a reasonable effort to disclose only the minimum necessary information required to achieve its purpose. The privacy rule gives individuals the right to request a covered entity correct any inaccurate PHI. Also, it requires covered entities to take some reasonable steps on ensuring the confidentiality of communication with individuals. For example, an individual can ask to be called at his or her work number instead of home or cell phone numbers. The privacy rule requires covered entities to notify individuals of uses of their PHI. Covered entities must also keep track of disclosures of PHI and document privacy policies and procedures. They must appoint a privacy official and a contact person responsible for receiving complaints and train all members of their workforce in procedures regarding PHI. The Fair Credit Reporting Act and the Fair and Accurate Credit Transactions Act, which amended the Fair Credit Reporting Act, applies to consumer reporting agencies, those who use consumer reports such as a lender, and those who provide consumer reporting information like a credit card company. Consumer reports are any communication issued by a consumer reporting agency that relates to a consumer's creditworthiness, credit history, credit capacity, character, and general reputation that is used to evaluate a consumer's eligibility for credit or insurance. The FCRA is a U.S. federal government legislation enacted to promote the accuracy, fairness, and privacy of consumer information contained in the files of consumer reporting agencies. It was intended to protect consumers from the willful and or negligent inclusion of inaccurate information in their credit reports. To that end, the FCRA regulates the collection, dissemination, and use of consumer information, including consumer credit information. Together with the Fair Debt Collection Practices Act, the FDCPA, the FCRA forms the foundation of consumer rights law in the United States. It was originally passed in 1970, and it's enforced by the U.S. Federal Trade Commission, the Consumer Financial Protection Bureau, and private litigants. The Controlling the Assault of Non-Solicited Pornography and Marketing Act, or CAN-SPAM Act, and the Telephone Consumer Protection Act regulate the collection and use of email addresses and telephone numbers, respectively. The CAN-SPAM Act covers all commercial messages, which the law defines as any electronic mail message, the primary purpose of which is the commercial advertisement or promotion of a commercial product or service, including email that promotes content on commercial websites. The main provisions say this: don't use false or misleading header information. Don't use deceptive subject lines. Identify the message as an ad. The law gives you a lot of leeway in how to do this, but you must disclose clearly and conspicuously that your message is an advertisement. Tell recipients where you're located. Your message must include your valid physical postal address. Tell recipients how to opt out of receiving future email from you. Your message must include a clear and conspicuous explanation of how the recipient can opt out of getting email from you in the future. Craft the notice in a way that's easy for an ordinary person to recognize, read, and understand. Give a return email address or another easy internet-based way to allow people to communicate their choice to you. You may create a menu to allow a recipient to opt out of certain types of messages, but you must include the option to stop all commercial messages from you. Honor opt-out requests promptly. Any opt-out mechanism you offer must be able to process opt-out requests for at least 30 business days after you send your message. You must honor a recipient's opt-out request within 10 business days. You can't charge a fee, require the recipient to give you any personally identifying information beyond an email address, or make the recipient take any step other than sending a reply email or visiting a single page on an internet website as a condition for honoring an opt-out request. Once people have told you they don't want to receive more messages from you, you can't sell or transfer their email addresses, even in the form of a mailing list. The only exception is that you may transfer the addresses to a company you've hired to help you comply with the CAN-SPAM Act. Monitor what others are doing on your behalf. The law makes clear that even if you hire another company to handle your email marketing, you can't contract away your legal responsibility to comply with the law. Both the company whose product is promoted in the message and the company that actually sends the message may be held legally responsible. The TCPA is supposed to restrict the making of telemarketing calls and the use of automatic telephone dialing systems and artificial or pre-recorded voice messages. The Electronic Communications Privacy Act and the Computer Fraud and Abuse Act regulate the interception of electronic communication and computer tampering, respectively. A class action complaint filed in late 2008 alleged that Internet service providers and a targeted advertising company violated these statutes by intercepting data sent between individuals' computers and ISP servers, known as deep packet inspection. The ECPA was enacted by the United States Congress to extend government restrictions on wiretaps from telephone calls to include transmission of electronic data by computer. It added new provisions prohibiting access to stored electronic communication and added so-called pin trap provisions that permit the tracing of telephone communications. The Computer Fraud and Abuse Act is a United States cybersecurity bill that was enacted in 1986 as an amendment to existing computer fraud law, which had been included in the Comprehensive Crime Control Act of 1984. The law prohibits accessing a computer without authorization or in excess of authorization. The only computers, in theory, covered by the CFAA are defined as protected computers. They are defined to mean a computer that is exclusively for the use of a financial institution or the government, or any computer when the conduct constituting the offense affects the computer's use by or for the financial institution or the government, or a computer which is used in or is affecting interstate or foreign commerce or communication, including a computer located outside the United States that is used in a manner that affects interstate or foreign commerce or communication of the United States. In practice, any ordinary computer has come under the jurisdiction of the law, including cell phones, due to the interstate nature of most Internet communication. In 2016, Congress enacted the Judicial Redress Act, giving citizens of certain ally nations, notably EU member states, the right to seek redress in U.S. courts for privacy violations when their personal information is shared with law enforcement agencies. The Act extends to natural citizens of designated foreign countries the principal benefits of the Privacy Act of 1974 to citizens from designated countries, which are already available to Americans. These benefits include the ability to access, amend, or sue for the improper disclosure of personal information shared with U.S. law enforcement or for purposes of preventing, investigating, or prosecuting crimes. A number of other countries, including those in the European Union, already extend such protections to U.S. citizens. The Act allows citizens of a designated country to bring a civil action and obtain civil remedies in the same manner, to the same extent, and subject to the same limitations as a U.S. citizen. A civil action under the Act can be brought only against a U.S. agency that intentionally or willfully violates the conditions for disclosing an individual's records without the individual's consent, a designated U.S. agency that refuses an individual's request to amend his or her records, or a designated U.S. agency that refuses to permit an individual to review records that pertain to him or her. There are many laws at the state level that regulate the collection and use of personal data, and the number grows each year. Some federal privacy laws preempt state privacy laws on the same topic. For example, the federal law regulating commercial email and the sharing of email addresses preempts most state laws regulating the same activities. Conversely, there are many federal privacy laws that do not preempt state laws, which means that a company can find itself in the position of trying to comply with federal and state privacy laws that regulate the same types of data, for example, medical or health records, or types of activity. Most states have enacted some form of privacy legislation. However, California leads the way in the privacy arena, having enacted multiple privacy laws, some of which have far-reaching effects at a national level. California, for example, was the first state to enact a security breach notification law, and this law requires any person or business that owns or licenses computerized data that includes personal information to disclose any breach of the security of the system to all California residents whose encrypted personal information was acquired by an unauthorized person. Most of the early state security breach notification laws mirrored California's law and tended to be reactive. That is, they established requirements for responding to a security breach. More recently, a number of states' laws have enacted more prescriptive and preventative laws. That is, these laws are more stringent and actually establish requirements to avoid a security breach. The best example of a preventative type of law is the Massachusetts regulation, which prescribes in considerable detail an extensive list of technical, physical, and administrative security protocols aimed at protecting personal information that affected companies must implement into their security architecture, and describe in a comprehensive written information security program. On the security front, as of March 2018, all 50 U.S. states, as well as the District of Columbia, Guam, Puerto Rico, and the U.S. Virgin Islands, have enacted breach notification laws that require businesses to notify consumers if their personal information is compromised. These new and amended state data breach laws expand the definition of personal information and specifically mandate that certain information security requirements are implemented. Companies who are looking to adopt an effective data management program may want to consider these items: auditing the personal data they collect, analyzing the nature or categories of personal data, and identifying which data is critical to the company. Developing a process for receiving, reviewing, and fulfilling customers' requests in connection with their data and requests to opt out of data collection, as well as how these requests will be operationalized. Developing and maintaining written data protection policies and security procedures, and training employees who handle personal data on policy changes, proper handling, and best practices. For some additional resources on this particular topic, take a look at the links I've provided. One is an FTC guide for businesses on collecting personal information, and another is a state-by-state breakdown of data breach notification laws.